Now it is my pleasure to introduce Tatyana Gray and Brayden Olson. Wood River Valley native, Brayden Olson is a licensed financial planner at MadisonPoole, located in Boise. He has a keen interest in helping families meet their planning needs. Tatyana Gray is a local attorney and the founder of Summit Legacy Law, specializing in estates and trusts, business transactions, and tax advisory. She works with clients to develop estate plans and provides tax strategies that minimize liabilities and enhance wealth preservation for future generations. So please welcome Tatyana and Brayden. Thank you very much.
Okay.
So I'm going to stop for just a second and let you know that Town Center West is undergoing some massive renovations, and part of those renovations are going to be a new sound system and a new projector system and new lights and new carpet and woohoo! So just thank you for your patience.
Well, sorry for that not recording, but anyway, we're here today to learn about estate planning, and the topic is how to keep your family out of court and out of conflict, and Brayden is going to add some valuable information on the financial end of things. This is a little bit more about me. I'm the founder of Summit Legacy Law. I'm an attorney. Originally, I'm from Russia. People often wonder about my accent, so just get it out of the way so nobody has to wonder. I came here as a student in 1998, went to college at BYU in Utah, got a degree in computer science, so I tell people that I can do some math. Then went to law school at BYU as well, graduated in 2006 in the top 10% of my class. Spent the next 5 years working with some of the best law firms in Utah, specializing in estate planning and also some business transactions and tax advisory. Then I came here and spent the next 10 years here being a mom, homeschooled my kids during that time, but also did some angel investing, some real estate investing, invented a gun safety device and kind of went into that route for a while. And then last year, I decided to go back into law. I had my license in Utah, but I had to take the bar in Idaho, which was not fun. But I passed the bar, and then I opened Summit Legacy Law earlier in May. And it's grown since then. We have some other people that help me. We have Ursula here. She is our executive and client support. And so she's kind of probably has more client contact, especially initially. So you can say hi to her. And then we have a remote paralegal, Brianna. She's not here, obviously. And then my fiance, Scott, helps with collaborations. And that is kind of how Brayden and I had this discussion about doing this joint presentation. So that is about it, about us. I'm happy to tell anybody more, later after this.
Yeah, can you hear me all right back there? So I just want to thank the library and for Tatyana and asking me to come help a little bit. And with anybody that has any questions, just reach out throughout the presentation. Happy to answer any questions. But a little bit about me. Again, my name is Brayden Olson. I grew up here in the Wood River Valley. My dad teaches high school at Wood River and graduated in 2019. Is when I graduated from high school here, I went and served an LDS mission in Ghana in West Africa. Spent some time there on a service mission. Came back and graduated from Boise State and with a finance degree. During my time at Boise State, I got connected with the firm MadisonPoole, did an internship with them, and they're located in Meridian. Been part of them, starting year 3 with MadisonPoole now, and I've absolutely loved it. I'm learning a lot, and I'm on a good team over there. Got some good mentors, and yeah, excited to work here in the Wood River Valley with all of you.
Okay. Well, we'll get into the meat of the presentation, and so I'm going to start with a series of questions. So question 1 is, since it's an estate planning presentation, this is a hypothetical question, just wondering, do you have an estate plan? And next question is, if not, why not? Are you too busy? Are you too young? Or do you think you're too old? Do you think it's too expensive? What are some reasons? And if you do have a plan, especially if you do have a plan, what is the reason that brought you here? Maybe you have a plan that was given to you by a lawyer, but you don't really understand, and you want some more understanding. Maybe you got a plan from LegalZoom and another online service, and maybe you just don't know how trustworthy that is. You didn't have that personal touch. Or maybe your plan was done 5 years ago. Maybe it was in a different state. Maybe you came to Idaho from a different state, and you're worried that your plan is outdated. Those are all valid reasons to be here, and we're happy that you're here. And for people who don't have an estate plan, there's some fears, and kind of these are the big fears that I've seen. And the first fear is very superstitious, that there's a belief there, well, if I go get an estate plan done, I'm gonna die. And I just want to assure everybody that it's purely a superstition. I have not seen that happen in my practice, and it's not something that we hear about. People don't drop dead because they get estate planning, unless they come to us when they're at the end of life. Another big fear that it will take too long, and lawyers are not notorious for taking a long time, being bad at communicating, and being very expensive. So those are kind of logistical fears. And then fear number 3, which might not apply to a lot of people in this room. You might not think that you're old enough, or maybe you think you don't have enough assets even. And so we're going to kind of address that. So you are in the right place if you have somebody you love that you want to protect. And that can be a spouse that you're worried about leaving, or it can be kids, can be grandkids. If there's somebody in your life, or even if it's a charity that you care about, then you're in the right place. Maybe, like I said, you did some kind of an online will or trust, and you're just not certain if that was done right, there was no human touch. And if you're nervous about costs or how long it takes or communication, maybe you're afraid to ask questions. So we're going to try to answer as many of these as we can. And in reality, estate planning is not just the documents. It's much more. I like to think of it holistically and go beyond the documents. And you can get documents pretty much anywhere. You can get them online, and documents are important. And as a lawyer, documents matter. But it's more than that, and it's not just about death. There's also perception there that estate planning is basically death planning. It is very much life planning, and we'll talk about different scenarios with incapacity. And for me personally, incapacity scares me more in that way. So with estate planning, we talk about incapacity as well, and how to prepare while you're still alive to prepare for that. And you don't want to be, I don't know if you have kids that are pestering you and make sure that mom, dad, did you do your wills? Did you do your powers of attorney? And you keep telling them, I will take care of it. I will take care of it. So we want to make sure that you get to take care of that. And you need to. So what you will learn today, we'll talk about the unexpected in life, and we'll talk about how people cope with that, how it can create conflict, how it can take you to court, and what you can do to avoid that. So we'll talk about a family, a fictional family, fictitious family, the Bliss family. And we'll go on a little journey with them. And we'll talk about the before. This family doesn't have any estate planning, so what happens with this family before any estate planning, and how their situation can be fixed with some estate planning solutions. And it's all kind of in the details. We'll figure out how to start, how long it will take, and we can even talk about how much it costs. So who needs your protection? Your loved ones, your children, your grandchildren. It can be friends. It can be other family members. So welcome to the Bliss family. They're just a regular kind of American blended family. We have Mark, Molly, and 3 kids, Alexander, Benjamin, and Caroline. And they also have 2 pets. Molly has an ex, Xavier, and she had Alexander with him. And then her and Mark, they have 2 kids together. So they're a blended family. Xavier, the ex, has a life insurance policy, and he named Alexander as his beneficiary. So we're going to follow this family and what happens to it. They also have a vacation home, so this should not be McCall, Idaho. This should be somewhere in another state, Utah, not Idaho. They're, again, just a regular family. Maybe this is, somewhat like your family was a few years ago. Maybe this is like your family now. Maybe this is like your kids' family. But they're going to get into some trouble. Life happens. So let's see what happens when life happens. Xavier, the ex, turns 40. And he decides he's in the middle of a life crisis. He decides to go skydiving for his birthday. Unfortunately, his parachute does not open, and he dies. But remember, he had life insurance, and he named his son, Alexander, as a beneficiary. So it's $1 million. Alexander's a minor. He's a teenager. So now we have a teenage millionaire. And what do you think he's going to do? He wants that fancy red car. Unfortunately, Alexander, as a minor, cannot take possession of that money. He needs an adult who would be in charge of the money while he's a minor. And this creates a problem because Alexander's mom thinks that she should control the money, but her ex's brother says that he needs to control the money. So how do we resolve this? Without an estate plan, they have to go to court. A probate judge is going to decide it. The probate judge is going to hear, maybe for 15 minutes, from the mom, and she's going to say, well, I'm the mom. He lives with me. Of course I should control this money. And then the brother says, well, no. My brother divorced this woman. She shouldn't have any of his money. I should be a more independent, neutral person to control the money. And then the judge probably would have like 15 minutes to decide. Who would he pick? Who would you pick? We just don't know. It depends on the judge. We don't know. So what can we do? How can that be solved with some estate planning? Well, if Xavier wanted this life insurance to go to his brother to take care of the son, he could have named the brother as the beneficiary of the life insurance. That seems to be a good solution, right? Well, not so. If the brother is named, and on social media there is a lot of bad advice, and that is one of the bad advices on social media. Well, your kids are minors, just like name your brother, name your sister, name your aunt. And I hear that in real life too. People think that they can trust that person, that that person will truly do the right thing. And maybe they would, but once they get that money, it's theirs. They can go spend it on whatever they want to. There is no obligation, legal obligation, only moral obligation, and people disregard those all the time. And even if that person is absolutely a trustworthy person, things can happen. That person can get divorced and money can be lost in the divorce. They can get in a car wreck, the money can be lost in a personal injury lawsuit. They can have a business fail, money can be lost in a bankruptcy. So that is not such a great idea. Well, what else? Well, what if Xavier had a will and said, well, everything I have goes to Alexander, but if he's under 21, then my brother should take care of it. Well, the problem with a life insurance, I don't know if any of you guys would know, with a life insurance, it goes outside of your will. If your beneficiary is an individual, it wouldn't go through probate at all. It doesn't matter what your will says. Your life insurance would go according to the beneficiary designation. So having a will for Xavier does not really solve this problem. And what Xavier didn't know, and a lot of people don't realize, that some assets go outside of your probate, they go outside of your will. You can't dispose of them by your will. And these assets would be anything that you own jointly with somebody else. If it's jointly owned property and you pass away, it automatically goes to the surviving person or persons. And if it has beneficiary designations, and Brayden will talk more on assets that have beneficiary designations, it will go in accordance with the beneficiary designations and not your will. So there are generally three buckets. Like I said, they're jointly owned property, that's kind of its own bucket. Then we have these assets that have beneficiary designations, that's a separate bucket. And then the last bucket is anything that is in your name that is owned by you individually. That is the property that can end up in probate. And probate is a court process, so when you pass away, something needs to be done with your stuff, with your assets. And the state of Idaho has a default plan for you. If you don't have your own plan, the state of Idaho has a plan for you. If you live in a different state, then that state has a plan for you. And that plan might not be something that you like, and might not kind of go along your wishes, and it doesn't take a lot of consideration for more of a modern kind of relationships that we have. So whether you know, for those assets, whether you have a will or you don't have a will, you're looking at probate in court. And here, Brayden is going to talk about the assets in that bucket number 2 that go by beneficiary designation.
Yeah, you bet. Thanks, Tatyana. So I just want to talk a bit about the different investment accounts a lot of people generally have and what happens to those after you pass away, and maybe some planning tips you could do in the meantime. So the most common investment account people have is an employer plan, like a 401k or an individual retirement agreement. So what happens with these is you're allowed to add a beneficiary to these accounts. So it's a good thing to add a spouse or your kids to these accounts. And as you pass away, it becomes an inherited IRA. If your spouse is still alive when you pass away, they inherit that as a spousal IRA, which is a good thing. They essentially just take that money and it's like their own. They'll get taxed as they use it, and there's no restrictions to it. But if you have an IRA and you pass away and your spouse has already passed away, let's say your kids get it, it becomes a non-spousal beneficiary IRA, which means they have 10 years to use the money. And most people say, well, that's not a big deal. My kids, 10 years, no problem. Well, it could be. Like if your kids are really successful and they're at a higher tax rate, and then you gave them this big IRA, now they're kind of in a tax bomb, which just means when they use that money, it now is taxed at their tax rate, and they have only a certain amount of years to get it out, and it could be a very unfortunate situation for your children. Another thing to note is what are called required minimum distributions. So when you turn 73 with these IRAs, you get a tax deduction during your working years. And when you turn 73, the IRS says, no more fun, I want my money back. And so they're forcing you to now take money out every year once you turn 73. Let's say you die when you're 75 and your kids get the money. Well, they think that they've got 10 years now to spend that money, but they don't. Since you were 75, they are now required to take your distribution every year, and maybe it's not a good time for them to do that. Maybe they or sold a business and their taxes are high. Well, now they got to take more income on top of that. Maybe they just got married and they've got a high earning spouse. Now they're taking more income on top of that. It could be a bad situation. So in general, IRA, 401k, make sure you got a beneficiary on it. Do some planning on who's going to inherit that, and make sure they know the timeline they've got on when they get that money out. Especially if you're over the age of 73, because then they've got to do that every year. They can't wait to the end of the 10th year. Feel free to jump in with questions too. Any questions about this? Another common account is a Roth IRA. This is a great estate planning tool. These Roth IRAs, again, you can add a beneficiary to them, which in general keeps them out of probate. But this money passes on tax-free. So if you pass it on to your spouse, it's just like their own Roth IRA, and they get to use it however they want tax-free. No timeline. I should note, though, that account must have been open for 5 years, or else it's essentially not a Roth IRA anymore. It just gets taxed as their ordinary income. And that rule's in place specifically because they don't want you to pay your taxes at a low bracket and then pass the money on the next year and they can use that money tax-free. The IRS makes you have that account open for 5 years. So it's a good idea to, if you're thinking about Roth conversions or moving some money in the lower tax year, just opening that Roth IRA, letting it stay open for a few years, and then doing that. If you pass it on to not a spouse, a non-spousal IRA, the 10-year rule still applies, except they get to take that money out in that 10 years tax-free. At the end of the 10th year, like in the 11th year, they're going to get taxed at their ordinary income. Essentially, the Roth IRA doesn't hold its advantages anymore. There's no RMDs for the spouse, and there's no RMDs for the children if they take it before the 10 years is out. So Roth IRAs are a great estate planning tool. If you've got money in a 401k or something, converting some of that while you're still alive could work out well for your children and for your spouses. Any thoughts on that? So these brokerage accounts, this is just money that's not qualified. It's not in a retirement account. If you're investing money in stocks, just through any brokerage firm, these you're not allowed to add beneficiaries on. So it's a good idea to do some planning around this, whether you have a will or a trust in place. That's Tatyana's specialty. You can add joint accounts or transfer on deaths, which just means you give direct instruction. Those you want to still be careful about, still have a will and a trust in place for these sorts of accounts. If you don't have a plan, it goes to probate like Tatyana was talking about. Some strategy around this is those qualified plans, the Roth IRA and the IRA, those all get paid at your ordinary income rate. But if you're at a brokerage account and you pass away, your kids or the beneficiaries pay no capital gains. So let's say you bought Apple for $10 and you bought $10 worth of Apple stock when you were 20 years old, and now you've got $100,000 of it. Well, you own, close to 900 or whatever the number was. I got lost in my math there. Essentially, you would avoid the big capital gains rate that you would have paid. You pass it on to your kids, and there's no taxes. So that could be something that's advantageous for you to think about instead of donating money from this account. Making some donations from your other accounts would be a good idea. So these are a great way to pass money on. You just want to make sure you're doing it within your wills and your trusts. The last thing I just want to touch on is life insurance. This always passes to your beneficiaries tax-free. Again, you can list your beneficiaries on there. If your goal is to pass money on, this is a great way to do it. We always say it's an effective way to pass money on, and it's a good use of your dollar. So in general, just make sure on your IRAs and your retirement accounts, you're listing beneficiaries on there and you've got a good plan in place. For those brokerage accounts, make sure you've got a will or a trust in place just so you don't leave it up to the judge on who gets to use that money when you pass away. And then in terms of Roth IRAs, make sure you got them open for 5 years before you pass away. Try not to pass away within those 5 years if you do open it. Try to really stay alive. So things to be mindful of. Yeah, if you're on year 4, really hang on because your wife might have things to say to you once she goes after that. So any questions about that? Go ahead.
On the one where if you're over 73,
Yep.
what was that again, that if it's left to your children, whatever? You said something about they have to take your
Sure.
R&D, or-
Yeah, the question for those watching online was regarding required minimum distributions, RMDs. So when you get your tax deduction during your working years, it's good for you now, but down the road, the IRS they own part of that account with you now. They want to get paid at some point. And they don't want you to hold on to it until you die and then pass it on, right? They want to get paid while you're alive. So that age keeps going up. It was 71 a few years ago, and now it's 73. But when you turn 73, you're required to take money out of your IRAs and your employer plans. So when you're 73, you're taking money out. But let's say, okay, you've been taking that money out and you're 75 now, and you pass away. Well, your kids, when they inherited that, they typically would have 10 years to spend that money, to get that money out of the account at their tax rate. Well, if you were 60, they could wait till year 10 and then take the money out, no problem. That's what a lot of people like to do. They say, I don't want to deal with this right now. Let me wait a couple years, and maybe I'll stop working, and so my taxes will be low, and then I'll take Pop's money, and that'll be a good thing. But if you're 75, those RMDs continue to your children. So let's say this year you have to take $10,000 out of your retirement accounts. When you pass away, your children will still need to take that $10,000 out, and it'll be more next year because the IRS wants you to get that money out. Does that answer your question?
Yeah, I think, but what I'm a little confused with, could they take out more?
Oh yeah.
As long as they take out the minimum,
Yeah.
that's not a problem.
Yeah.
But they could take, if they wanted to just bite the bullet and take it
Oh,
all
yeah.
out and take a big tax chunk,
Yeah.
do that as well.
Yeah, the question was, could you take more out than the minimum? And the answer is yes. Some people like to take everything in year 1. That might not be a problem if your account was smaller. But if you've got $1 million account, that's going to be a heavy tax burden to take all in year 1. Right? So some people like to split it up and take equal payments over that 10 years, keep their taxes about the same. You could take it all in year 1. You're just realizing that much. You're adding that much income to your taxes that year.
If it was $1 million, you could take $100,000 each year.
No problem. Yep.
No problem.
Yep. That's the minimum that you've got to take that year. You could always take more. Yeah. Just like when you're alive. Yeah. Great question. Anybody else?
If you don't take that required minimum distribution, what kind of penalty is there?
Yeah, well, the question was, if you don't take the required minimum distribution, what's the penalty? It's kind of a gray area in the IRS code right now. As of today, the rule is 50%. So if you don't take your required minimum distribution, let's say it's $10,000, you owe the IRS $5,000 next year of that distribution. That's subject to argument, really. Let's say you file your taxes and you could just say, hey, look, I forgot. I didn't know. Any reasonable argument to why you missed that RMD, the IRS typically takes it. We've never had them not accept like an apology, really. And what you do is you just back pay those and send that to the IRS, say, hey, I took this RMD for that year. I'm sorry I missed it.
So you file an
Amended return, yeah. And they're normally okay with that. But yeah, as of right now, they want 50% of whatever that RMD was. It's not fun, and it's not fair, because people miss those all the time. that answer your question?
Yes, thank you.
Yep, no, you bet, good question. Anything else? Yeah, RMDs are tricky. They're based off of how your life expectancy and your spouse's life expectancy and multiple tables, and they get complicated, but there's calculators online that could help with that. You want to make sure you're taking at least what you're supposed to that year. And most people do. I mean, most people need that income in their plans anyways. But yeah, it's good to spend those accounts while you're alive. Unless your kids are at lower tax brackets, then it might be good to pass it on. But yeah, definitely a good thing to sit down and do some planning about. Yep. And you want to make sure you're not leaving your kids with an excessive amount of RMDs while they're alive. Yeah. Anything else before I throw? Go ahead.
Still on the same topic.
No, you're good.
So if you're over 73 and you're taking your RMD out,
Yep.
and you pass away and it's left to your wife who's well under 73, does she have to keep doing the RMD or?
Yeah, good question. The question was if you're taking your RMDs and you pass away and your wife inherits, does she need to take the RMD? The answer is no. On spousal inherited IRAs, there's no RMDs while she's alive.
Until she turns the age?
Until she turns 73, then she does. Because when you inherit your spouse's plan, it's almost like it was her money in the first place, which she probably would say today that it's her money too. But, yeah, at the end of the day, if she inherited it, it becomes her money. There's no RMDs until she turns 73.
Great, thank you.
Yeah, you bet. Yeah, good questions. Any last things before I give back to Tatyana? Well, great.
Okay. We'll get back to our Bliss family, and I started touching on this big myth. Again, the kind of probate and probate avoidance is often a big topic, and there's some misconceptions, and the biggest misconception is probably that if you have a will, you're still going to probate. A will does not avoid probate. If you don't have a will, it's probate. If you do have a will, it's probate as well. And in Idaho, considering the probate is not that bad. It's not that expensive. It doesn't take that long. So if your only goal, if all you've heard is that you need a trust, which we'll talk, you need to avoid probate. You need to avoid probate. That might not be necessarily the case because in Idaho, again, probate is not that bad. And you have a handout that talks about some of the rules of thumb, because people ask, well, do I need a will? Do I need a plan, a trust? And so there's some quick kind of rules of thumb of when you might want just a will plan or when you might want a trust plan. And so that's yours to take home with you. And I even thought about making a video just going more in depth because I won't have time today to get into those differences. And so when you also have the green sheets where you can give some feedback to us, and if you want me to make this video, I can email it to you. So if you want on your green sheet to make a note, then I can send you the link to talking specifically about that issue. But anyway, so back to this Bliss family and talking about trusts. One of the best ways to avoid probate is a living trust. And how many of you have heard of living trust? Probably everybody. Just briefly, what is a trust? You probably all know, but a trust is it's a mechanism. And later we have a slide, it's a vehicle. It's like a little red wagon. It's a container. And for a trust to be valid, it needs to have 3 players involved. It needs to have at least one person who makes it, the trustor. It needs to have at least one person who manages it, the trustee. And it needs to have at least one person who benefits from it, the beneficiary. So those 3 roles need to be filled. And then if you're creating a revocable living trust for estate planning, you'll be initially in all of those 3 roles. And your trust also needs to have some property in it. And we usually initially put just $10 in, and we'll worry about all the other property eventually. And also because there's another misconception there, with revocable living trust, you get no asset protection because you control everything. You are the trustor, trustee, and the beneficiary. So you retain complete control during your life over your assets. So there is no asset protection for you. There might be asset protection after your death. So it can be a solution for somebody like Xavier because he had a minor child. He can establish a trust where he would say that his brother would be the trustee or the manager of this $1 million for the benefit of Alexander. And he can be very creative, and he can have provisions to where Alexander doesn't just get this $1 million outright when he turns 18, where the money is spread out in ages and stages or built in further asset protection. So a trust is a will substitute, and it doesn't go through probate. Now, with these 3 buckets of assets, with your jointly owned assets, if you want to have a trust, you need to fund it, so you need to give assets to the trust. If you have joint assets, you might want to put your ownership interest into the trust, breaking joint tenancy, basically. If you have beneficiary designations, you might want to name your trust as the beneficiary. There can be some special considerations, especially with retirement accounts. You don't want to miss out on the spousal rollover IRA options. So that gets a little bit tricky with retirement accounts, and you really should consult somebody like Brayden or myself, a professional that can help you with that. But most other beneficiary designations, you would want your trust because it acts as a common distribution scheme. So you want to make this decision kind of once, and then everything points and goes into your trust and follows that same distribution scheme. And then all of the trust assets become immediately available to your loved ones when you pass because there is no probate. You don't have to wait for the court to sort it out. So again, it's like a little red wagon that goes outside of the courthouse, but it has to be, the stuff has to be in it. If you don't put your assets, if you don't fund your trust while you're alive, you're still going to probate. And it might be, again, it might be okay. You still will get a common distribution scheme. You can get asset protections. You can get a lot of other benefits out of the trust. But if you don't fund it, it's probate. And we work really hard to make sure our clients fund their trust during their lifetimes. So you must fund your trust. So lesson number 1, you need to know what you own. You need to review your assets. You need to figure out if it's owned jointly with somebody else, if it goes by beneficiary designation, or if it's in your name, in your individual name. And one of the things, one of the big fears was, well, I'm not wealthy enough. And often we have clients who come to us and we help them prepare an asset inventory. And when they sit down and they actually take the time to write down their assets, and then we show it to them, they're surprised. They're like, oh, wow, I didn't know. I didn't know I had this much money. So if you think you're not wealthy enough, you might be. Just maybe never sat down and wrote it all down in one place. So this poor family, things keep happening to them. They decide to go ski at Sun Valley, a family ski day. Unfortunately, it gets foggy, and they have, the mom and dad, Molly and Mark, they have a big accident. They have to be life flighted to Boise. But what do you think happens to the kids? The kids are out there skiing, and they're minors. Does anybody know what might happen to the kids? The authorities would get involved, right? And the authorities might not know where the kids are going to go. The kids might have to go spend a few days with CPS. They might have, in this scenario, Molly has a sister Mindy, but she's in Florida. By the time she finds out, gets her arrangements made, it takes her 3 days, 4 days to get here to try to take care of the kids. So meanwhile, the authorities wouldn't know what to do, so CPS. They might have friends here. They might have friends in the valley, but friends are not even related to the kids. The authorities won't just let the friends to take the kids overnight. Remember, they had pets too. What is going to happen with the pets? So what can we do for a family like that? For families with minor kids, and this is very important for me because I have minor kids, we usually talk about short-term guardianship, and if you have children with grandchildren, you should tell them. And this is somebody they appoint in the vicinity. Now, your kids might be, or you might know this, having the guardians. You might be guardians for your grandkids long-term, but what happens if it takes you a while for the guardian to get there? 3 days, 4 days, a week. So we talk about the short-term guardianship where parents would appoint somebody who is local, who can be there, who can come to Sun Valley and pick up the kids. And the authorities, if they have papers, make sure that the papers are shared to these people, that they have copies so the authorities would trust these people. And I don't know, here, I know with me, I have, and we do this for clients with young kids, I have wallet cards. And this is the emergency card that I carry in my wallet with my driver's license. And so this says that if anything were to happen to me, there are 4 people I have here that can be called that live in the vicinity, that can come and pick up my kids if something were to happen. So something like that is really good to have. And you know, if something does happen, the authorities come and they try to identify you, so they will go through, try to find a wallet. And the same, you can have these documents for your pets. I know that we love our pets here in the Valley, so we want to make sure that we take care of them too. But things are not over yet, and this maybe would become more relevant to you guys with stays in the hospital. So what happens if somebody is in the hospital? And it can be due to an accident, it can be due to illness, it can be due to age. So somebody's in the hospital, they're unconscious. And for now, Molly's husband is making medical decisions for her. But what is going to happen long term? Remember, they have no estate planning documents. And her sister is flying in, she's calling the hospital, wants to know what's happening. The hospital won't talk to the sister because under HIPAA, they're prohibited. There's no authorization for the sister to talk about Molly's medical condition. Meanwhile, the husband can't access his wife's accounts. For whatever reason, they had separate accounts and he can't access them because his name is not on the accounts. And now we see more and more nowadays where we have spouses and they have separate accounts. So what is to be done? And again, this can be relevant to you guys as well, not just to the younger families. If you don't have an estate plan, you're in a hospital, you're unconscious, you have a spouse, maybe you have children, maybe they disagree about what's to do with your health care. What is going to happen? It's court. They will go to court, they will ask the judge to appoint somebody to be your guardian and conservator, so you're in court. And again, who is the judge going to choose? In this case, we have the husband and the sister. How's the judge going to decide? I don't know if any of you remember the Terry Schiavo case, like went on forever and ever with that poor woman where her husband wanted her to be let go and her parents, I think, wanted her to be kept alive. There was nothing there, no estate plan, so that it just went on forever, made national news multiple times. So what is there to do? What's a better alternative? So Molly herself can make all of these decisions, so there is no need to go to the judge. And this is where the planning for your incapacity comes in, and I think it's just as important, if not more important, than preparing for your death planning, because it can solve these situations. There are documents that you can prepare. You can prepare financial powers of attorney. You can prepare health care powers of attorney, where you decide now, if something were to happen to you, who are the trusted people that can act on your behalf. And obviously with financial power of attorney, it would be anything pertaining to your finances. Her husband, Mark, would be able to access her accounts and make the payments, pay the bills. You can pick trusted people who can help with your situation if you were to become incapacitated. With healthcare, gets a little bit more involved because there is HIPAA you have to worry about. So you need to make sure that there are HIPAA authorizations for people you want to help. There is the healthcare power of attorney that appoints somebody to deal with medical decisions for you, and usually it involves consents to surgeries, consents to different drugs, consents to different procedures or testing. So you can delegate that to somebody without needing to go to court. And then there is the living will. So things get worse for Molly. So now Mark can pay the bills. So the only person other than you who can make these decisions is the judge, so don't let that happen. Things get even worse for Molly. She passes away, and she's end of life. She was found to be terminal, and this is more of the Terry Schiavo. She's a persistent vegetative state. So what is to happen in that case? And you can deal with that with a living will. And have you guys heard of a living will? There's some confusion because we have a will, which deals with probate and distribution of your assets. And then there is the living will, which sometimes is called advance directive. And the living will only deals with end of life. You have to be found medically to be terminally ill or in a persistent vegetative state before your living will kicks in. And it only deals with artificial life-sustaining procedures, and that can be dialysis, can be a ventilator, can be hydration, feeding tube, stuff like that. So you can have this document filled out, and you can decide now about your end-of-life care. And of course, you have to be incapacitated for that document to kick in as well. And I often just think about how hard it was for me to put down my dogs to make that decision. And with a living will, you're making the decisions about your end of life. You're not putting it on somebody else. Like, I would never want to put that decision on somebody else, like my kids. So with that document, you usually have choices. You can either decide that you want to be kept alive with all of the artificial life-sustaining procedures. And I actually had an idea. I don't know how valid it would be or not. But another option is to have no artificial life-sustaining procedures and let you go. But if you opened your Roth IRA and you're 4.5 years in, could you say, keep me alive until it hits 5 years? I don't know. I just had that idea. And after that, remove everything. I don't know. Maybe it would be valid. But that is what your living will document does. You decide right now if you would like to be kept alive artificially. It all means possible. You can decide that you don't want to be kept alive artificially at all. Or there's some middle grounds where you can say, I want hydration, I want nutrition, but I don't want any other machines. And you always, in the state of Idaho, you always get comfort care, so you always get pain medicine and some other just comfort procedures. So it just gets more and more complicated. I'll try to go quickly because this just shows you how, if you don't plan, just all of the other bad scenarios, we're kind of looking at the worst case scenario. But so now we have this boy, Alexander. He lost his biological dad. Remember, he died in an airplane crash, or parachute did not deploy. Now his biological mom passed away. So he has his stepdad, and then he has a grandma, a biological grandma. He's still a minor. He needs a guardian. So now there are no documents, no estate plan in place. Now there's a fight between stepdad and biological grandma. They go in front of the judge. Who will the judge choose between these two? We don't know. Depends on the judge. Also, with their cabin, pretend it's in Utah. If you live in one state, you have real estate in another state, you might be looking at ancillary probate in that other state. So double probate. So what could be done with estate planning for this family? Living will, like we said, Molly can make her wishes known for her end-of-life care. She can choose who would be the guardian of her son. She can appoint the stepdad. She makes that call, because then the kid can stay with the siblings, and grandma gets to be just the grandma. She's not going to be the primary caretaker. Vacation home If it's put in the trust, it avoids the double probate. It doesn't have to be probated in Utah or whatever the other state is. But again, you must fund the trust. If you don't fund the trust, you're facing probate. Now Mark ages, and he eventually dies too. And then like Brayden talked about the IRS, they want their cut. So they're gonna come after you first if they can. Thankfully, the estate tax exemption is so high, it's almost $14 million per person. This year, it's like 13.61. 2025, it goes to 13.95 million. There is a sunset in 2025. If the Congress does nothing, then in 2026, it's supposed to go back down to 5 million adjusted for inflation. But now that we have control, like this is not political, but now with the full control of the three branches of the government, the expectation is that the estate tax exemption is going to stay high. So most people are probably safe when it comes to federal estate taxes. In Idaho, thankfully, we don't have any other inheritance taxes. But in our neighbors in Washington and Oregon, in both of them, definitely one of them, Washington, I believe, they have state level death tax. So if you're here, but you still have any real estate in Washington, you might end up paying estate taxes there, or they call them inheritance taxes or death taxes. So if not federal government, it can be state government that can be coming after your estate. And with retirement, again, it can get pretty complicated if you have retirement accounts that have significant value in them. Like if it's $1 million or above, I would say that you probably need some advanced planning. So question for you, how much does the IRS get? When Prince died, of course, he was ultra wealthy. They got $120 million from his estate. Some other concerns for you who have minor beneficiaries, probably grandkids at this point. If you give the money outright, first, if they're minors, they cannot really do anything with it until they reach the age of majority, so somebody else is going to control that money. And second, even if they're younger adults, they might not be wise enough. They might not be ready enough. If you're wanting to leave them hundreds of thousands of dollars, the fear is that they can just go blow it, get into bad stuff, and it's not really going to be a benefit or a blessing for them. So revocable living trust, like I was mentioning, can help you structure how you want that legacy passed in different ways. One of the popular ways is ages and stages, to where you can do a third, a third, a third at 35, 45, 55, something like that. You can do more of an asset protection. If it's more money, you can kind of have more asset protection for your grandkids, kids and grandkids as well. So you can be creative. So this, just talking about, again, estate tax is not that big of an issue for most people. And this is lifetime asset protection just for beneficiaries who are too young to be responsible. And you also can have trust for your pets, because if you don't, your pets are usually not an asset, they're a liability. So it is unfortunate, but often the pets end up in shelters, and you can have provisions in your trust. Your pets are property, they're personal property, so you cannot leave your pet money. You need to have a trust where you appoint a manager and a caretaker. So this is more about IRS. And the last slide, really, what is it really like for your loved ones after you're gone? What kind of legacy do you want to leave? Do you want to leave a mess where there might be court, where there might be fighting, or do you want to have a legacy that you think through and that is structured? So they will miss you. Well, and yeah, there's more to your legacy as well than just the assets. There's, of course, your insights and values and stories and experiences. So don't forget about that when you think about your legacy. And this is it. We're happy to take your questions. And this is my contact. I don't, Brayden, if you have cards. Yeah. And if you wouldn't mind, if you're, can give, well, it would be for my Google review. If you enjoyed this presentation, if you wouldn't mind giving a Google review, I appreciate those. They help bring more people to events like this. And so if you have questions, we're happy to take some questions.
Question for Brandon.
Yeah, you bet. Let's hear it.
If I'm retired and have no income other than dividends and interest, annuities, and Social Security, if I establish a trust with all my assets in a state like Texas without state income tax, could I stop filing Idaho state tax?
Yeah, the question was if you've got all of your income and you reside in Texas, could you,
I still reside here.
or if you still reside
Could I
here,
establish the trust under the laws of Texas and it was inside of Texas?
that's a great question, and I don't know the answer to that, honestly, dealing with the multi-state. So if you had all your income,
I don't think that would. Again, I'm also not 100% certain, but if it's a revocable living trust where you're in complete control, it would be your residence that would matter. Yeah. If you pass away, the trust becomes irrevocable, and then you can move the location of the trust if you have those provisions. But if you're a resident here and you have just a revocable living trust, you control everything, I believe it still would be on your
So after
Idaho taxes.
the first settler to die, then it could become like that.
Possibly, yeah. It's something that would require research. I don't know off the top of my head. But I know that with irrevocable trust, you can change the trust's location. So that might be beneficial. But again, it's a research question.
that's a great question. Yeah.
Well, it seems like my ratio between my federal taxes I owe and my state taxes, the state keeps getting a little.
Sure. Yeah. No, that's great. Happy to do some research for you too.
How do you handle a situation where you have a piece of property, one piece of property, but you have two children, and you don't want that to end up creating conflict between them? How do people handle that?
Yeah, so the question is if you have a property and two children and you would want to benefit both of the children and make sure that they feel fair. Well, if there is no desire to keep that in the family, then easiest is to sell and divide the proceeds equally. If you do want to keep it in the family, if it's like a family cabin of some sort, you would put it in a trust and probably would provide some funding to take care of that, because you don't want that to be a burden for your children where they now have to maintain, repair, pay property taxes. So, does it answer your question or not quite?
Yeah, I think so. I'm wondering too, what if it's not a piece of property that's a vacation home or something, but it's a primary residence, and that's the only piece of property, and you pass on, and that property's still
Yeah.
there. How do you get that divided up? And it's a piece of property that either one of them would be happy to live in.
So the follow-up question, if it's a personal residence and either of the children might want to keep it for themselves, a good solution is to do a right of first refusal. So when you pass away, either child has an option to buy it, and you can either do it by lottery if you think they both are equally interested in it, or you can say which child gets to decide first if they want to buy it or not. Lottery probably would be more fair at that point, and you can decide how they value it. You can say that they have to go get it appraised, or that they go by the county assessed value, and then whoever gets the right of first refusal to purchase it would just have to purchase it from your estate. And then, you can have additional provisions, how that can be done to where they basically have to give the other sibling half of the price. Maybe use other assets from the estate to do that, to equalize it. Yes?
So say that he wants to do this with his property, can he just write this up, print something off the internet and say, if I pass, I want my house to be sold and divided, between my kids? Or does that have to have a lawyer or something? Is this something you can do on your own, or you have to have?
Well, the question is, if it's something like that, or I guess any estate planning, can you do it online, or do you have to have a lawyer? You do not have to have a lawyer. There are services online where you could do it. Most of the time, they're more on the budget side, of course. And I think if you have something straightforward, that might work. If you're getting into these more complicated issues, it might be good to just sit down and talk through things with a lawyer. Like I said, well, how do you make it fair? Do you want to do a lottery? Do you want to, So you could, but whether it's the wisest decision.
I know this is a hard question, but I'm interested in, say, the average cost to do a basic will and a trust, assuming IRAs and retirement funds, but not complicated in other ways.
So the question is on pricing, and for our practice, it's a range, probably. Well, if you're a married couple, it's between $2,000 to $6,000. If you're a single individual, roughly half. But without knowing exactly kind of the complexity, I can't give a quote. But it's a range, and some lawyers charge hourly, which is unpredictable. And there's a lot of movement towards these flat fees, so it just depends. I'll just quickly add that I would recommend that wherever you go, you find a lawyer that specializes in estates and trusts and not just a general attorney, especially if they're more complicated things. Okay, well, thank you so much to everybody for being here, and it was a pleasure.